What is unjust enrichment in the context of a lawsuit? Well, the very short version is it means somebody got stuff that they shouldn't get and it's unjust and you should give it back. But this is actually insanely more complex than this. To sue someone on this, it's not something like when you sue for defamation, when you sue for a car accident, for negligence, when you sue for many of the other traditional ways that you sue someone. It's actually more interesting legal theory, and I guess a nice introduction if you want to be a law student or if you have any interest in the law to learn a little bit about how lawsuits work. And you may have seen this in some of the celebrity videos that I've done about their lawsuits. It sort of pops up from time to time, and I say, oh, this is going to take a whole separate video to explain it, and so I'm doing that video now. So unjust enrichment is a legal theory is like the short way to put it. It is a way to sue someone. Okay, but it is more complex than that as to like, what do I mean a way to sue someone? Because there are different sort of theoretical ways that you can go into a lawsuit and justify recovering money or stuff from someone that you're suing. One thing that you see in every lawsuit, every civil lawsuit, is what's called a cause of action. A cause of action is one of these legal theories that if you meet a checklist that they call elements, so it'll be 1, 2, 3, 4, whatever. You have to allege sort of facts about someone or facts about the situation you're in with them. That if you check every check in the box, and then you go to a jury and prove that, then you win money or win whatever. It doesn't have to be money. You could be stuff. It could be a thing that you gave someone. They could be ordered to give it back. But part of one of the complexities to that is that, okay, there's this theory that lets you get something. Well, what can you get? The question of what you can get is something a little bit different that's called a remedy. A remedy is, let's say you say someone libeled me. They went online or whatever, and they were just saying all kind of bad stuff about me and it was false. What can you get if you win that? Remedies are the things that you can get, and remedies can be all kinds of different stuff. They could be, they're real complex in the context of contracts, which if you're a first-year law student, you'll have a lot of time learning about remedies, and there's even separate classes on remedies apart from your mandatory contracts class in your first year. So unjust enrichment, well, which one is it? The answer is who knows, and because courts disagree about this in different states, I'll show you a little bit about that in detail in a minute. And they fight about what it is, what it means. At its core, it is something that is generally agreed to be what is called an equitable something, either a cause of action or a remedy. Whatever it is equitable versus legal. So there is law and equity in the law, which sounds confusing, and maybe it is. So when lawyers talk about the things that you can sue people over, they will talk about you have legal or equitable remedies or causes of action or whatever. Legal means you kind of, it's hard to, I guess, pin down a little bit, but the basics of it is that you're kind of following the traditional legal rules of these checkboxes. Equitable is kind of a fill in the cracks, right? So you can, sometimes there are things that happen to people that don't really fit within all of the different like ways to sue someone that we've come up with, or all the different, if a contract's breached, the thing you're asking for doesn't really fit within what you're supposed to be asking for. But it's considered sort of unjust, or when they say equitable, is it inequitable? Is it unjust for someone to just not be able to sue in a certain situation? And so the courts have what are called equitable powers, the power to do equity. And that just means the power to do justice. So if the court finds itself in one of those situations, the plaintiff can say, hey, look, I want you to use this equitable remedy, which unjust enrichment is sort of in that category of, it's the backstop. It's the thing that you use if nothing else works. And I'm going to show you some case law now about case law is just these legal opinions by judges that I thought were interesting. The more you want to delve into it, and it explains kind of like, how does this work in different states? Because, and I will caveat this at the very beginning, this stuff is like this particular thing, this concept, the nuances of it, the details of it are very, 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 very different across different states. They're all fighting about it. People have been fighting about it for hundreds of years. It's a very old theory, and it's one that like all these different states had this thing for hundreds of years, and they all kind of customized it and made their own little version of it or whatever. And so everyone now, if you go to one state versus another, it's the same concept, but like different rules. And the little checklist is a little bit different in every state. So let's look at the first one I'm going to show you is Georgia, because I found a judicial opinion that is quoting what a judge told a jury about this, the instructions he gave to the jury. And it's a pretty good high-level summary of what this is, even if it may not be exactly the same as other states are. Okay, first, I'm going to read you this part, and this is what went to the jury, and then I'm going to scroll up a little bit and show you the example of the situation here, which is a good example of when something might fall through the cracks and you would want to sue someone on unjust enrichment. So this says, and this is literally what the judge would have read the jury in this case. He would get up, the judge would be in there, the parties would have fought about, like, what should you tell the jury, and he would just take this text I'm reading you and he'd read it to the jury. And I'll stop it a little in the middle and explain some of this because it's kind of complex. So it says, a claim of unjust enrichment will lie if there is no legal contract and the party sought to be charged has been conferred a benefit by the party contending an unjust enrichment which benefited, which the benefited party equitably ought to return or compensate for. So what does all this mean? So when it says a claim of unjust enrichment will lie, that just means that it will kind of like go forward. It's a valid claim and you win. Then it says, if there is no legal contract. So this is one of these things that they kind of fight about sometimes in the different states. But in Georgia, this is saying that you can only sue someone for unjust enrichment if they don't have a contract. So that's the idea behind doing it that way is this is supposed, that kind of thing about this is supposed to be the fill in the cracks. If there's a crack in like what's just, or a way that something is falling through those cracks, then you can use this. But when they say you can't use it if you have a contract, the idea would be, okay, if you have a contract, then there are these other legal remedies that you can follow versus this one that's supposed to be only for whenever we need to do justice, like kind of outside those rules. And so you have to have someone who doesn't have a contract in Georgia. And when it says the party, this is all sort of complex language, but it's basically saying the guy who's getting sued has conferred a benefit, which means giving you money, giving you stuff, giving you some kind of benefit, and you were unjustly enriched, which just means you got a bunch of stuff that really you shouldn't get to keep. Should you have to return the stuff or compensate for the stuff or whatever it is? It could be money, it could be anything. Then the judge's instructions say, the concept of unjust enrichment in law is premised upon the principle that a party cannot induce, accept, or encourage another to furnish or render something of value to such party and avoid payment for the value received. And so it's basically saying you can't like kind of trick somebody or whatever into giving you stuff and then be like, haha, I tricked you. You're done. That's my stuff now. And, go pound sand. You can't get it back. The idea is like, if that is unjust, if a jury's looking at it, or maybe a judge is looking at it and going, you really shouldn't keep this stuff that you kind of got improperly through your trick or your encouragement or whatever, then you can sue to get it back or get the value of it back. So it may be something you can't recover your stuff back. Maybe it's something that got used. Maybe someone tricked you into giving them a bottle of $10,000 wine or something and you drank it. So what do? You get the value of that wine back. Then the judge said, thus, a claim for unjust enrichment exists where a plaintiff asserts that the defendant induced or encouraged the plaintiff to provide something of value to the defendant, that the plaintiff, so this is like that checklist. That's the one. The defendant has to have basically, if I'm the guy suing, then you, the defendant, have to have encouraged me to give you something of value. So in my example, that would be like the wine, that the plaintiff provided a benefit to the defendant with the expectation that the defendant would be responsible for the cost thereof. So that means, like, let's say it's this wine scenario, it's an old bottle of wine. You're like, oh, dude, I got this friend who, like, I'm going to go drink it with him and he'll give us the money. Like, you give me that wine and I'll go grab the $10,000 in cash from my friend and we'll be back and we'll give it to you. And so, but if it was just like, hey man, can I have that wine? And you say, all right, dude, take it. Then that wouldn't meet this second part of the checklist because I was not, if I'm just like, hey, take my wine, I'm not expecting compensation. It's just a gift. That's two things you got to check. 3, and that the defendant knew of a benefit being bestowed upon him by the plaintiff and either affirmatively chose to accept the benefit or failed to reject it. So that would be kind of in the scenario. Basically, it's kind of covering situations where the defendant didn't know like that this was even happening. Like you get something somehow, like maybe like the wines, let's say the $10,000 wine example, there's like a bottle of wine sitting out and everyone's drinking it. And I take a glass. I'm like, oh, we're drinking wine. I just think we're drinking wine. I think it's like $10 stuff from the grocery store. And then everyone looks in horror and they're like, wow, you drank $1,000 worth, pay up. That wouldn't be covered by this kind of theory because I don't know that I'm getting this extra benefit. but then I would have affirmed, I, in that situation, would have, I guess, chosen to receive it, but not known about it. But if someone was like, hey, that's $1,000 glass and, that's going to cost a lot, right? And I'm just like, okay, and drink it, then I probably meet this part of the checklist. And then it says, the last part the judge said was, for unjust enrichment to apply, the party conferring the labor and things of value must act with the expectation that the other will be responsible for the cost. So that means if I'm the one like giving you the wine, or let's say I'm doing work for you, because this comes up a lot when people like contractors or something do work thinking they're going to get paid, but there's maybe not a contract. But then like, why would they be doing work for some random person not getting paid? I have to in my head expect like, okay, you're going to cover this, right? If I'm the one suing, you're going to pay for that wine because we're all putting in $1,000 for the bottle and everyone gets glass or whatever, something like that. So let's scroll up here and look at what happened. This was just the instructions, and this got affirmed by the appellate court. That means the appellate court said that, yes, this is a fair, good explanation of Georgia law. What was actually being sued about in this case? They always in these opinions sort of explain like the basic factual scenario, like what happened. So they say that there was this unmarried couple living together. They moved into a house owned by this person, Kate's. A couple years later, the parties bought and co-owned a successful restaurant, and so that was paying for all their their restaurateurs. They got cars, they got all kinds of stuff. And then the other one, Brown, in this couple, don't know which one's which, but Brown contributed money for the improvements for this house that they bought. And so they put in a new deck, a pool liner, a rock patio, interior modeling, and then they buy the house next door, I guess, to invest in, they say. And then Brown gives a down payment on the house because under the belief, this is the key part, under the belief that Kate's would add her to the house's title, but did not do so. So this Kate's person, Roger Cates, so that's the guy, the husband in this couple, or unmarried couple, not the husband, the guy gets the woman to basically remodel his whole house, pay him money for a down payment under the idea that she's going to get added to the title, so she's paying part of the down payment for the house, and then he just drops her. He's like, oh, sorry, you paid all this money for my new pool, and you paid me all this stuff, and you're gone, and you don't get anything. So that's a scenario where you can see why that would be, even if there's no contract between them, even if there's no, they didn't have a deal where maybe for the title, but they may not have said expressly, here's this deal, but why would she be giving him all this money for no reason? Why would she be just giving the guy a pool? I mean, it's not really the kind of thing that's like a gift. And so it's something where you can see if she's in a long-term relationship, she thinks they're going to stay married. He has gotten all this benefit. He's got a pool. He's got half his down payment. He's got a patio. He's got all this other stuff. If you start asking yourself, what's just here? They can't divorce. They don't have a marriage. So the law can't deal with it that way, because if they're not, they're just kind of an unmarried couple. So there's no real way for her to get that back unless you have this theory of equity where it says, the judge or the jury says, okay, or they can say, and maybe you think something different, but this is something where in this kind of situation, you can see how people would think that. They would say, maybe he should pay her something for all this stuff that he got when she was giving it to him on the assumption that she was going to be part owner of the house, or she was going to be, living in the house that they put the pool in or whatever. It's not unfair to expect him to sort of contribute some of the money back to her so that it's kind of even if that expectation wasn't met. So that's the type of scenario where this kind of claim could come in. There's many others, but this is a high level, how does it work? May not work the same in your state. But let's look at a couple other opinions just real quickly to see kind of what other states are saying about this and kind of some of the wrinkles in this, especially because there may be law students watching this, and this maybe will help you understand at kind of a high level, what do I need to study? Okay, so this one is a case from Texas, and this I'm showing you this because it lays out the theory a little bit differently in a way that some other states may have that is kind of interesting. So it says they're doing the elements. You see element, that's that each element, when lawyers talk about that, is one part of the checklist. And they say, the way they say this is, or the way the Texas court words it is different. It says, a party may recover under the unjust enrichment theory when one person has obtained a benefit from another by fraud, duress, or the taking of undue advantage. This is the part that's very different from, and you may not sort of notice exactly why it's different, but because this is a checklist, you have to meet all these parts of this. So it has to be one of these three things. That's a lot more restrictive than what we looked at in Georgia. So fraud is something real serious. That's where you're lying to someone. Duress is where there's some pressure that forces you in, it could be like pressure, like a gun to your head or something like that would be the classic example. Doesn't have to be that bad, but someone who's like elderly and is confined to a bed, and then someone's like, I'm not going to feed you unless you do this, or like, oh, they start lying to them, like, oh, your kid's going to die if you don't sign this or whatever. Taking of undue advantage is just a general thing like that, right? Like if someone's got dementia and you're like getting them to sign stuff, that would be undue advantage. But this is different than what we looked at in Georgia. Let's look back at Georgia at this instructions here. So this just says, like, this doesn't have anything about fraud, duress, or any of that stuff. So in Georgia, you don't have to prove that. You just have to prove the defendant expected it, right, and all this other stuff. But we never talked about something. It had to be one of those three things. That means in Texas, this unjust enrichment theory is a little more limited than in Georgia, because in the Georgia case we're looking at, there's no allegation, for example, that the guy lied to the woman. She expected the title was going to be in her name, but there's nothing saying like that guy came and said, yeah, you'll get the title. Honey, just put it on there and you're fine. There's no allegation that he had a gun to her head. There's no allegation that she had any kind of mental issue. And without any of those, in Georgia, she would win this, but in Texas, she would not. And so if you're someone who disagrees with that scenario we were talking about earlier, like who should get it, which of the two, in Texas, they would have this kind of more narrow level of backstop. And this says that, it kind of has other stuff on it, but that's the key, difference, I guess. And it also calls it a cause of action, which is another thing I'm going to show you some other cases on real quick that get into one of the big fights you see about this, about unjust enrichment in different states. So now we're looking at a court. It's a California court that was actually going through the law of a bunch of different states. It starts with California, and this problem appears to exist in a lot of them. This kind of legal question is unjust enrichment a remedy or a cause of action? And that's what we talked about earlier. Remedy is something you can sort of give if you win a cause of action, and a cause of action is like you can win because you like show unjust enrichment. And I'll see if it can show this difference a little clearer here. It says some federal courts have noted that California courts appear to be split on whether unjust enrichment can be an independent claim or merely an equitable remedy. And so what this is saying is that the courts in California, and this is true in a lot of other states, are kind of like not in agreement. They will just issue these legal decisions that are total opposite of one another, which is what a split is. And some will say, oh, you could sue for unjust enrichment in the same way you would sue for defamation or libel or negligence for a car accident or something like that. You can just file it on its own, and it's its own thing. That's an independent claim, and that means if you just show those things we were talking about earlier, it'd be different from California for their rules a little bit. But if you check all the lists, then you win. But then there are other ones that say it's merely an equitable remedy, which means you have to win something else first to then get the unjust enrichment. Like the way to simplify this a little bit is like or maybe make it more complex, I guess. I don't know. Contracts are the situation where you have a lot of what are called these remedies. If you breach a contract with someone, let's go back to the $10,000 wine example. If I have sold you the $10,000 wine and I still have it, and then I don't pay you the $10,000, there are different remedies. The remedies are the things the court can give you. There's different ones that might make sense there. One of them might be give me $10,000, right? Because what we were supposed to do, what we expected in our bargain was, I'm going to get 10 grand and you're going to get an expensive bottle of wine. Another remedy that you could do is give me back the bottle of wine. That's something where like you could order that the wine come back to me. So unjust enrichment is, for some of these courts, is considered like, okay, you win. It may not be a breach. Some of them actually say you can't sue if there is a contract. But let's just use breach of contract as an example. Unjust enrichment might be like, okay, you breached the contract and now there's something unjust about this that you're holding a benefit and didn't give to me. It could be, there's other types of causes of action where this might be something, that is the appropriate remedy for it. That I'm trying to think of some examples of it. There's stuff, one called money hadn't received. There's like conversion is something where you take something that's not yours without permission. So like if I'm like caretaking your house and then I'm allowed to kind of be in there, but then I grab the bottle of wine and run off with it. That's something where you can see how unjust enrichment would make sense as a remedy to that conversion claim. But then what you would sue them for would be what is called conversion. And that is a whole separate video to talk about that one. So that's why I'm making these individual ones. These legal concepts get very complex, and you kind of like have to pigeonhole them to. That's why you have to go to law school for 3 years. So that's California, and they start talking about all these like courts are disagreeing on this stuff, which is something that you will see in a lot of places about what a lawyer can do. It matters strategically if you're a lawyer. Like, how do I win the case strategically? Unjust enrichment can be helpful. Like, there's a lot of people who try to use it in class action claims, where there are scenarios where someone has gotten stuff but hasn't really fairly given it back. Like, I think an example might be, say, like you sign up for a pay-per-view boxing fight, and then the transmission goes out. So you've paid someone money, but you never got the benefit you were expecting, and it's kind of unfair for them to keep the the money. And unjust enrichment, the reason that people have wanted to use it in class actions in some cases, and sometimes it's worked, sometimes it hasn't, but it's a theory where it can kind of be uniform. Like, if you it's important for class actions to be as uniform as you can be. That tends to make you win more often. So if you're the plaintiff, you want the injury to be like the same for everybody. It can be like that gets even into its more own complexity for the class action, but the more similar, the easier to win, I guess, as the plaintiff. So let's look at some other stuff. So this is a case from California that I picked because it has a real interesting fact pattern that is kind of, I don't know, funny but not funny. So it's CBS is filming one of those like police procedural shows, NCIS New Orleans. And so they get these two people who are like background actors, and they tell them, like, we're going to film a scene of an armed robbery. So you guys, here's some like black costumes, here's some ski masks, here's some like high-powered automatic assault rifle props. And then they drove in an unmarked van to this store. And the store owner knows they're coming, right? He's in this. And there's a concealed camera inside, and they basically tell these two background actors, like, look, run out of the van with your fake assault rifles and just storm in and start yelling stuff about threats and cash and jewelry. But CBS and the show did not obtain filming permits, nor did they tell the police or anybody around or the businesses or like anybody in the area, hey, there's going to be this fake armed robbery. Instead, they do it what's called guerrilla style filming. So they literally see the CBS people just send an unmarked van up with a bunch of people in some two men in ski masks, jumping out with what look like assault rifles, running to the store and start screaming stuff at the owner. So his neighboring businesses, the people who are like next to him, are like, oh no, they call 911. The SWAT team shows up. They like, really could have got these actors killed, to be honest. And so the police like drop them to the ground, take them to jail, are like, what are you talking about? And there's a whole big thing. And they finally figure out this is a TV show from CBS of all places. Like it's a real show. So you're wondering, like, what do they do? And then like after that, what happens to these people? CBS tells them not to talk to anyone, but they start complaining, and then CBS blackballs them. So now they can't be actors anymore. Blackballs means CBS like tells everyone else. The allegation is that CBS told everyone else, like, don't hire these two men. They're totally difficult to work with. If they ratted us out to the cops whenever we sent them in with these assault rifles and ski masks to do the fake robbery and went to jail. So yeah, that's what happened. They sued under unjust enrichment, but this is actually a case where the court said unjust enrichment does not apply to this facts. Why did it not apply? What the court said is that these two actors can sue for other theories. So unjust enrichment is designed for, and this is a California case, so this may not be the law elsewhere, but it basically said it's to fill in the gaps. And so you could sue CBS for fraud, and they did sue for fraud. You lied to us. You didn't tell us that we were running into this mess, and we acted assuming that we were fine and that you'd done all this stuff, and then now my life's ruined because I got arrested and I'm all over the place on TV and all this stuff. And so the court was just like, the reason you don't need this equitable theory is because we already have a remedy. This is not falling within the cracks, and so you don't need to use this unjust enrichment. And this is one of those states that treats it, a little more like, or at least this court did, because sometimes they even disagree about that, right? Like there's different law, there's different arguments on the law. But in places that think, oh, unjust enrichment is like only there to fill in the gap, the court said, look, if you got something else, and it goes forward, then you don't need this unjust enrichment. Didn't mean they couldn't win money for this absolutely ridiculous scenario, but it did mean that they could not use that particular theory to win money. They could sue for something else. And this is something that gets to that point as well, is that it's a Washington case. So again, a different state with different rules. And this Washington case set out their rules, and it says that you basically can't get unjust enrichment if there is a breach of contract. If there's a contract an unjust enrichment out of the same conduct or same subject matter, that's inconsistent because breach of contract like sort of covers the case, and then again you don't need this gap filler. But what this court made clear is you can do something called pleading claims in the alternative, and that's something plaintiffs are generally allowed to do, definitely in federal court. But the idea is pleading in the alternative means even if your claims are you can't win both at the same time, you can plead both of them. Pleading means raise, like in your first or alleging in your original lawsuit. Like you can go in, and even though those two things might be totally inconsistent, you can say, yes, there was a contract and they breached it and have to pay me money for that. And also they have to pay me money under unjust enrichment because there wasn't a contract, and if there wasn't a contract, I get money that way. And the idea behind this is the plaintiff doesn't know what facts are going to get proven. And so this specific example is a good example of why plaintiffs are allowed to plead in the alternative, because the defendant might say, aha, there's no contract. And then you're at the end of the lawsuit going, well, I should be able to get unjust enrichment now. There's no contract. And the court might say, well, you never said it at the beginning. It's, we're at the end and you didn't argue this stuff. And so what the plaintiff does basically when they plead in the alternative is say, okay, well, who cares what's true? If there's a contract, then I win breach of contract. If there's not a contract, then I win unjust enrichment. Either way, give me money or stuff or whatever. And so that sort of is how, as a practical matter, lawyers, and as a strategic matter, if you ever become a lawyer and you want to try to win your lawsuits that way, you always want to make sure if there's something that could go one way or the other, then pleading in the alternative protects you as a plaintiff later on in the case. So if you see in one of these celebrity lawsuits, people alleging this, that's why they're doing it. It is often a strategic decision by the attorneys. They are trying to make sure that they have this backstop, this thing for if their case does fall in the cracks, because it can fall in the cracks sometimes. Sometimes you end up at the end of the case finding out that things were very different than what you thought they were in the beginning when you're the plaintiff, because usually the defendant knows more about what's going on than the plaintiff. Not always, but a lot of times you're suing someone who has like their own documents and they kind of know what they did and they won't tell you, and they never want to tell you. And that's just how it works. And so that's why these lawyers are doing this. If you're a lawyer or if you're a law student, you definitely want to learn all these remedies. If you're going to do litigation, it's very important. It helps you win your cases more to know like what can I sue on, because there are a ton of the stuff that you've heard about, breach of contract, defamation, things like that. That's the tip of the iceberg. There are a ton of different theories you can win lawsuits from against people on. Lawyers will always put in more than one because they want to have backups. And this one is kind of an interesting one because it basically ultimately just gets back to the jury's kind of saying like what's fair, what's not fair, or the judge saying what's fair, what's not fair. And that is really it's not even kind of about the law. It's just about like, what does your gut tell you about should someone get the money back? Should the person get their bottle of wine back? Should the woman in that relationship get compensated somehow? And that ultimately, if you're an advocate, if you're a lawyer, you're advocating for your client, you have to tell a good story. You have to make sure that your client, especially the plaintiff side, a lot of winning is about picking good cases, because when you're the plaintiff, you get to pick who you represent. You don't have to take cases like you decide. And especially if you're on contingency, you make sure that you got a good case. And whenever you get up to that judge, they're going to be like, if they do what's fair, then you win. So if you want to hear more of these videos, not just dense legal explanations, well, you'll get some of those, but you'll get more kind of crazy celebrity cases and interesting cases where they're just kind of fun to see what happened. Hit subscribe, or you can go click onto whatever videos are on the end cards here and go see some more.